if you are ruling a civil matter, if you are in civil law jurisdiction, like the American system, you use the preponderance of evidence. That's the scale for determination of cases, on the preponderance of evidence, or on the preponderance of evidence means on the weight of evidence. How much evidence do you have to prove it? In common law jurisdictions like ours, like Kenya, for instance, that's what I mean by ours. The scale used is on the balance of probabilities. That is more probable, that this situation is more probable than the alternative. So, and if you are determining a matter in a criminal case, the scale that is used is beyond all reasonable doubt. So, if I'm to prove a case against an accused who is criminally accused, I have to demonstrate that indeed there was a crime, and that crime was perpetrated by the accused because the accused demonstrated intent to act in the manner described. So he demonstrated intent to act in the manner described, and indeed they acted in the manner described, and such actions and the intention, they constitute a crime, being described. So those are universal templates. But is the basic structured doctrine a universal template to that degree, such that it informs constitutions and constitution making? Was it used as a template for our constitution, the Kenyan 2010 constitution? Was it the template? Is it implied? Fine, you may argue that in bringing the Building Bridges initiative and proposing the introduction of the office of the Ombudsman, you are changing the structure of the Constitution by undermining the doctrine of separation of powers. Okay, the doctrine of separation of powers is a Madisonian doctrine. It was first brought into the shores of the United States by the third president of the United States, James Madison. He's the one who exercised the doctrine of separation of powers to its greatest extent. Was it the intention of the framers of the Constitution that there be such a thing as the doctrine of separation of powers? I know the answer to that would be most probably yes, because of the way they have framed the Constitution and the system of governance, such that the executive cannot interfere in the affairs of the legislature. or the judiciary. So the purpose of the legislature is to curtail the powers of the executive. For instance, in the approval of budgets, the approval of appointments, the approval of appointments and budgets and all those things, that they have to be made by parliament. The executive cannot also interfere in matters of the judiciary, such that when in the appointment of the Chief Justice, it's done by the judiciary itself and its commissions. The commissions under the judiciary, like the Judicial Service Commission, is the one that conducts appointments for appointment of judges. The president can only do as much as confirm the appointment. He cannot change the names. Though our President Uhuru Kenyatta went to the extent of refusing some appointments, but that is the much he can do. He cannot propose appointments. He can only confirm appointments of the judiciary. So that's how independent the three arms of government are. So that is within the spirit of the doctrine of separation of powers. So by introducing the office of the ombudsman, it can be argued that the structure of the constitution was being changed. But even if it was being changed, isn't it understood that it can be changed by the sovereign through a referendum? Is it the argument of the court that for you to change the structure of the constitution, you have to do it by exercising the powers of the primary constituent power? If that is the argument, does it not then, is it not a coup on the constitution itself? Does it not undermine the sovereignty of the people and the supremacy of the constitution, such that the basic structure doctrine as a reference material in this case becomes superior to the constitution because it's the one that is advising the court on its ruling on the matter? Think about those things. Thank you.